Hello and welcome to Reasonable Doubt. My name is Murray Newman and I am the president of the Harris County Criminal Lawyers Association, and I am your host tonight along with two very good friends of mine. First of all, we have my dear friend Lauren Byrne.
Hello.
Who is a fellow defense attorney, who is joining to talk about some interesting topics that have gone on this week and specifically today.
Yes.
Also joining us is my law partner, Cheryl Chapell.
Hello.
And she and I have been law partners for coming up on 4 years now.
Yep.
It's her first on-air appearance. I think you did one by Zoom many moons ago when you penned a very famous resignation letter.
I just wrote one. I didn't pin it.
This is the first time you've been back.
Yes.
Since then. So we have a lot of things going on, a lot of things to talk about. We started off by announcing that we were going to have the show to talk about some laboratory irregularities that have been going on in Harris County that Lauren's going to talk to us about, but also there's been a really big article dropped by the Houston Chronicle this afternoon talking about the intake procedures at the district attorney's office and how they are often getting overruled in court for a lack of probable cause. But I do want to start off by talking about the lab issue that we have. So Lauren deserves all the credit for this because she's the one who kind of discovered it and brought it to not just HCCLA's attention, but the court's attention and the media's attention. So Lauren, tell us a little bit about what you got.
Sure. So I have to give a little bit of credit to Justin Kiter, as much as I hate to do it.
No.
He put a little bug in my ear when I was talking about an issue with him, and that kind of set me down this path.
Okay.
Briefly, I had a client who was on bond supervision, and he was ordered to test weekly. And he was insisting, like many clients do, that he was no longer smoking marijuana, and he didn't understand why he was still testing positive. He then mentioned to me, after many, many weeks and many, many bond violation reports, that he still didn't understand it. He had just tested for a job and had tested clean. And, I thought, let's look into it. Let's see what we can do. And I had him start doing his own independent tests on a weekly basis, going to any lab test now or someplace like that.
Can I ask a question real
Sure.
quick? Was his offense at all drug related?
It was.
Okay.
It was. The court was very understanding. Like they were not trying to revoke somebody's bond for marijuana. But at a certain point, when you continue to test positive, they at least want to address it. So the lab tests he was doing, were coming back negative.
Okay.
I then noticed that with Avertest, he would be positive 1 week.
Do you need us to talk while you clear your throat there for a second?
I also have some banned water in my purse if you need some.
So I think Cheryl asked the question, was this a drug-related offense?
Yes.
And you said no. And,
No,
and
it
that's,
was.
I'm sorry, you said that it was, but that's a good point, that some courts have you test whether it's drug-related or not.
Well, because the DA's office, no matter what the offense is, they're always asking for ankle monitors, drug testing, no matter what.
And there are some judges
so.
that insist on it too, across the board.
Right, and the idea being that the DA's office is looking for a violation because they hope that they can revoke your client's bond and have power over them when it comes to
pressure to plead.
Pressure to plead. Yeah.
Poppin'.
So he tested positive 1 week, he was negative the next week, and positive again the third week. And that stood out to me because I thought if you're smoking marijuana, that you're not going to be positive 1 week, negative the next, positive again. If you found a way to beat the test somehow, why wouldn't you have been doing it every single time?
Right, and we all know kind of, even though none of us are chemists or biologists, we all kind of know that marijuana tends to stay in the system longer.
Sure.
So it's unusual to have an on, off, on again.
And that happened at least twice in the lab results. And so credit to Judge Colleen Guido. She was patient with me. She granted a court order for me to get records from Avertest. I wanted all the chain of custody documents. I wanted all of the underlying data for the tests, and that's where I ran into some problems. They would not provide the underlying data They gave me a whole song and dance. Oh, we really can't. It's just you can buy a litigation packet. They weren't giving it to me.
Can I pause and ask a question?
Sure.
Is number one, is Advertest, did they have an exclusive contract with the county for all the testing for people on pretrial bonds?
Yes. I want to say, at least as far back as 2019, there was a contract for pretrial services. It was originally with a different company that Advertest bought out. But apparently, I didn't know this until recently, Advertest is one of the few national companies that advertises their ability to do mass testing at a very cost-effective rate. And so almost every probation office in Texas uses Advertest. Harris County's probation department uses Advertest, and pretrial services uses Advertest.
So when we talk about pretrial probation, that means that not only are they there before you've been placed on or receive a sentence, these are also people that if a person pleads to probation, they're doing the drug test
Yes.
for all of that. And so they've basically got the whole enchilada on this market.
They're in at least 34 states doing a lot of family court, parent drug testing and CPS type cases. They've got a pretty big market share.
And where are they based out of?
The lab itself is in, I believe, in Missouri.
Okay. And so at this point, to catch you up before where I interrupted you,
Sure.
you've got concerns because your independent testing is not matching what they're saying.
Right.
Okay, so.
I never got to actually verify any of that because they did not give me the underlying data. I had a court order from Texas, and before I really pitched a fit and got further into that, I found a different avenue to go because when I was researching Advertest and they were giving me a hard time on the phone, the guy was polite enough, but he was just not going to give me the data. And Justin Kiter had kind of shown me, he was like, oh, right there on the website, you can see if they're accredited, who their governing accrediting body is, all of that kind of stuff. So I went and looked. I want to say this was October of last year, and it showed that they were no longer accredited as of November 2022.
And what does that mean in the big picture?
To boil it down, certain types of forensic evidence, as laid out by the Texas Forensic Science Commission in the code, if you want to use it as evidence in a trial, if you're trying to connect the evidence, say, you know, this is what we're arguing it to be in any sort of matter, controversy like including bail and bond specifically, it has to come from an accredited lab, something that the Texas Forensic Science Commission considers accredited. There is an exception in the administrative code, though. If it is a probation department or parole, and they are doing routine monitoring for purposes of are you in compliance with probation or parole, that testing does not have to be done in an accredited lab. It has other requirements that it has to meet, but the lab itself does not need to be accredited.
Okay.
So I realized, well, they're not accredited, and since my client is being supervised through pretrial services, and this is relating to a matter of bail or bond per the code, it should be an accredited lab. At that point, I called the Texas Forensic Science Commission and I had a conversation with Lynn Garcia, who I think is general counselor. She's, you know, up somewhere at the top of the commission. And she agreed that the law says what it says. Nobody's ever really pointed that out.
Was she not aware they weren't accredited?
No, they were. The Forensic Science Commission sent them a letter. Here's what happened. In her words to me back then, not to any county official now, but back in October, early November, she told me that the commission had decided in 2022 that they wanted to remove CAP, the College of Association of Pathologists. That is the accrediting body.
That was over the lab.
That was over the lab.
Okay.
So CAP accredited a number of labs, and by virtue of being CAP accredited, they were accredited with the Forensic Science Commission because the commission recognized CAP, if that makes sense.
It's like a 3-year bar card.
Yeah. They had found, not Advertest, but other labs that were accredited by CAP. In her words, there were some horrific atrocities that had occurred. Quote. And based on all of that, they had decided that CAP was not properly supervising, and so they had voted to remove CAP from their accreditation list. And so in 2022, I want to say June, they sent a letter to all labs that were accredited by CAP, including Avertest, to let them know that they were removing that. And if this in any way affected their, the labs they were doing in their business, they needed to reach out. They had till November for this to go into effect.
Okay.
Avertest never reached out. They never told pretrial services or anyone at the county, despite the requirement that they be accredited being in their contract with the county.
So we know that the county didn't know, or we don't know that the county knew?
So I did look into that, and I mentioned it to the guy at Avertest, and he goes, oh, no, we don't do that kind of, that's like for forensic labs, we don't do that kind of testing. I don't know if they had a misunderstanding as to whether the exception applied to them or not, but they never called to figure it out or ask, and nobody else ever, looked. I can't say definitively one way or the other, but I did a PIA request with pretrial services, and the director was very nice. She called me, we talked, and she had sent me. There was nothing I saw that indicated they knew it wasn't accredited. And in fact, when somebody had inquired about this back in 2021, she had documentation where she had checked it all out to address their concerns. And in fact, it was still credited at that time. Now, that's to say, I don't know that anybody routinely checks.
Yeah,
Probably should.
I mean, it's kind of like saying, officer, you're still a cop today, right? I mean, it's just one of those things that you just assume they would notify you if something had changed.
You would think the company would have notified. They denied even having communications with the commission until I literally pulled up the letter and started reading it to him and who it was addressed to, and he goes, oh, maybe we did.
And to be clear, this is something that could bankrupt them. I mean, they have a huge contract, I would presume.
They have very large contracts through the state of Texas, and particularly with Harris County.
Yeah.
Pretrial, just like every other agency in Harris County, I mean, they're busy, they're overwhelmed. I don't know who would be responsible for checking that regularly or once a year or anything like that. Point being, they were not accredited from November 2022 on. And we know people had continued to be tested, and
But doesn't this just go towards the argument of bond conditions should be more narrow anyway? And wouldn't that help with a backed up lab not being able to do all of the tests they're being asked to do?
Sure. I mean, yeah.
That's insane. But dial it forward to January, right? And now.
Well, so I figured this all out. I was waiting for some more records, and I got a little distracted by other things. But I came back around, and I talked to the commission again. And I had tried to PIA the DA's office to see if they had any indication. They were the ones that had the question back in 2021. Because apparently Avertest, in the rare occasion that they ever bother to come testify, because apparently that's an issue too, they're supposed to come, but they don't like to. Their analysts had testified that they weren't accredited because they didn't realize they were. So I put it all together, and I emailed pretrial some of the judges, and I just said, hey, here's this information. I have no reason to think that anybody knew anything about this, but here's what the law says. Here's my conversation with Ms. Garcia. The powers that be will do what they want with it, but I think it's an issue, and we shouldn't be relying on unaccredited labs' work to revoke people's bonds.
And Ms. Garcia said?
Well, let's just say everybody, the judges took it very seriously. They were appropriately concerned. They wanted to immediately get into it. I mean, swift action.
Right, yeah, as they should.
But the director of probation, I didn't even realize at the time probation was Avertest. She immediately started saying, oh, that's not true. She's wrong. She's just saying that. Like I wasn't
Saying
even.
that you were lying?
Oh, yeah. Like.
Who was that?
Teresa May, Dr. Teresa May.
Yeah.
Told another judge who immediately called me and said, just FYI.
Teresa May's basically saying.
I was like, I wasn't even trying to say anybody in Harris County did anything wrong. It's just an issue that needs to be addressed.
So CAP, the status of CAP right now?
As far as I know, I want to say on the agenda they were considering reapproving CAP because that would help address their issues. Suddenly, the horrible atrocities were not so horrible anymore. But what they did do, what they have done, is by January 19th, because like days after I brought this to people's attention, they already put on their agenda for the Forensic Science Commission to change the administrative exception to also include pretrial supervision. Labs that test pretrial bond conditions are now accepted.
Instead of fixing the problem, they're going to
There's an exception for it.
Yeah.
I think they freaked out because Avertest has such a giant
Well, sure.
contract within Texas. And
It's too big to fail.
It's too big to fail.
Yeah.
So they very quickly fixed the problem versus addressing the issue.
Well, and the thing that kind of strikes me on this, and Cheryl, you know, you probably have your own experiences, but I mean, we've all had clients who test positive for drugs while on bond or on probation. But it's kind of rare that they go, there's no way that happened. I mean, I can think, I mean, I've certainly had clients, you and I had a case that was resolved recently where the client was testing positive for marijuana
talk about that, Murray.
a lot. It's DA privilege, yeah. But we'll just say that when confronted with the positive drug test, there wasn't a lot of no ways to that. But Cheryl, have you had that where you've had a client who tested positive that said that's just got to be wrong?
Yes, but fortunately in that situation, we had a judge that said,
I don't care.
well, yeah, okay. Don't let it happen again.
Well, and you know, and it's interesting right now because, you know, most judges that we have on the bench right now wouldn't revoke for a positive, at least not a positive marijuana.
There's enough that do.
I said most.
I mean, that's what bothered me because the analysts are really refusing to come testify. I don't want to get, Justin Kiter still has a case pending, so I won't say too much, but he had a hearing where they testified by Zoom over objection, and he filed a writ. The judge ended up saying, you know what, I'm just going to put the bond back so we don't have to litigate all this. But it was an ongoing problem. What I didn't know at the time, I didn't realize I had triggered probation. And they did this knee-jerk reaction to kind of patch it up. I had a reporter out of New York reach out to me when she saw like the little daily article in the Chronicle. Apparently, she's been researching and investigating and reporting on Avertest for years now. And they're currently under investigation by the Department of Justice.
Wow.
They are under investigation by the Michigan Health Department. There's a federal lawsuit from people from 6 different states. They had a whistleblower who was in their lab for maybe 6 months in 2020 who said, hang on, guys, we are not doing best practices. They are trying to ram through mass quantities to get results, and they're not testing the proper way. And she estimated 30%, up to 30% of their lab results were wrong.
Wow.
And she testified. They actually had been on probation from CAP, the very accrediting body that the commission says has poor oversight. Even they felt Avertest needed to be on probation. I don't know that any of that was ever disclosed to Harris County.
Well, and now that it's out in the open, though, I mean, I'd return back to Cheryl's question. They're still doing tests every day? I mean, we're still using them?
I can't say. I know that at the time I emailed the judges, they were meeting and trying to address it, and I feel like some of the judges, based on the information they knew at the time, did not want to use Avertest. And to their credit, they didn't want to use a lab for, even though there was an exception for probation, they didn't like the way it looked to use a lab that wasn't accredited despite the exception. Now, what's happened with the contracts with Avertest? Has that changed since they fixed the problem? Are we still using them? I can't say.
I mean, when you have a contract like that, you know, to undo it and find somebody new, it's a major undertaking. That's not something that you just do in the course of a day.
I will say that there was apparently a secondary contract that they had in place. They were using Avertest, but they had a backup. The county had a backup. And I was told that within about 1 week of me notifying everybody, they were pivoting to use that other lab until they could figure things out. I assume that is what happened, and nobody gave me the follow-up information as to what decisions were made.
Well, I know that I had like a private conversation with at least one judge who felt that based on this and how long it had gone on, that AverTest ought to be investigated criminally.
Well, apparently they already are.
It's like just add them to the fire there.
Maybe not criminally, but they are under investigation. Those plaintiffs involve a lot of parents who, one much like my client, was doing her own independent testing and yet tested positive on the AverTest lab and had her parental rights terminated. I mean, there's
Jeez, horrific.
a lot of people have been affected by AverTest, and that lawsuit is still ongoing. I had several people reach out to me from the defense bar about instances that didn't add up. I couldn't investigate. They wouldn't give me the records. I found a different avenue to go down, so I never got so far as to say in my specific case, an expert would say there was an issue. It was just, it didn't smell right, and I dug in.
So, you know, a while back, a mutual friend of all of ours, Lisa Andrews, had a similar type of scandal with basically people and their positive drug test. How familiar are you with that?
I am, because I remember Lisa kind of got a court order to storm the lab with no notice, and that's when she saw, you know, all the unlabeled, just the samples everywhere. I kind of wish I could have done that, but they were in, you know, Missouri. Not so easy.
Yeah. And was that AverTest or completely unrelated? That was pretrial though, wasn't it? The way they were collecting.
No, that was the probation department. That was back in the day before we had an official pretrial services lab. And what she did was she went into the collection site within the criminal courthouse where they used to be on 12.
Yeah.
And she went in with her investigator and like took photographs, and there were all kinds of, if I'm recalling correctly, like unlabeled urine samples, like stuff just kind of everywhere. And she figured or theorized that perhaps her client's sample had been switched with somebody, because nothing was labeled. It was just a total mess.
Well, but it all falls under the same umbrella of people who just really don't care whether they're getting it right or wrong before they're willing to say, hey, judge, you should revoke this person's freedom.
Well, that's just a big problem with the criminal justice system in total, right?
Right.
Like, you have officers who lie about things. You have people who don't care about whether tests are correct or wrong, and that's why we have jobs.
I was pleased with the judge's reaction. It was swift. It was, I mean, they were upset, and they were not going to be satisfied with the exception. I don't know what's happened since, because I haven't followed up to ask. Nobody's reached out to me to say if it's settled or not. I was also grateful to Judge Guido, because, I mean, at a certain point, I'm sure it's like a slap in the face to the court when you just continue. I mean, there was a lot of positives.
Yeah.
But she was very patient and let me continue investigating and digging, was willing to give me the court order to go in and get stuff, and kind of took it on faith that I was digging and actually looking for something and not just trying to extend my client on bond for as long as I could.
Right, good for her.
Well, and you know, and what I was alluding to earlier is that, you know, 10, 15 years ago, there's not a judge in that courthouse that
There wouldn't have been a hearing.
Yeah,
there still are a few courts where there's not hearings. They just look at the results, take them into custody.
Yeah, and thank goodness for your client that that's not the case for the court that he was in.
And that you're so good at what you do.
Oh yeah, that's it.
All right, if you're watching at home, you can, if you got comments or questions, we do have a phone number you can call in if you want to. You can also put into the Facebook chat, I believe, and it should show up. I do have an iPad here, so if you have any questions or comments for Cheryl or for Lauren, let us know, and hopefully I can make my technology work. So, shifting gears a little bit, we had a really interesting article that we kind of knew was in the works that came out today in the Houston Chronicle. And so, Cheryl, do you want to talk about that since you're not paying attention?
I'm paying attention.
Yeah. So for those of you all watching at home, if you haven't checked the Chronicle website today, a big article came out. Who were the authors on that?
It was Nina Satiha. I'm not sure if I'm
I thought it was
pronouncing
Satji, but I
honestly,
could be butchering it.
You know, I've never asked
Name
her
is
how to
Nina.
pronounce it.
Yeah.
I've always called her Nina.
Yeah.
And Nicole, right?
Andrea Ball?
Yeah.
Was also working on it, and I think Nicole was third byline.
Nicole Hensley. Yeah, and they talked about something that we see every day. It wasn't particularly news to us, but talking about the district attorney's intake office. So, Cheryl, why don't you tell us a little bit about how intake works, just in general?
Right now, like how the intake currently works?
Right. Like, what's the idea behind intake?
That before officers actually file the charge on someone that they've arrested, they call the DA's office intake and they run the facts by them, and then the prosecutor typically says, yeah, we have enough, we'll accept that charge, or they ask a few more questions to try and understand what exactly is going on, and then they accept the charge, or they decline. And when they decline, sometimes they either forward it to an investigator, so no one gets arrested, no one gets brought down, but an investigator will follow up, or they just decline them outright. And an intake division is extremely important in those situations because sometimes officers just want to take a lot of charges that maybe they shouldn't.
Yeah.
Even when, I will say, police officers a lot of the time, they know exactly what's going on. They know maybe criminal activity is afoot. But if you can't legally get there in the correct way, those charges have to be declined. And sometimes that's why that prosecutor at DA intake is important, because they'll say, yeah, that person probably was drinking and driving a couple hours ago maybe, but we can't prove that it was right now.
Right.
That's how intake works.
On the flip side, it's important to ask the right questions.
Right.
And make sure the correct evidence is collected, because you might reject a charge where somebody could really be in
Should have
danger, or
been,
something
right.
very legitimate could have happened, but the officer didn't articulate it in a way that got you there, and you didn't follow up.
Well,
So it's got a lot of consequences both ways, I think.
Right.
But when I became a defense attorney and realized that not all counties had an intake system like this or direct filing, I was really surprised, because I always thought of it as something that was very much a benefit to everyone involved. At least during my time as a prosecutor, and we're all former prosecutors, but I thought, it helps the cops make sure that they're making a good case. It helps the prosecutors make sure that they're not bringing in garbage cases, and it helps the defendant if they're out there and they have a chance to go home right there on the street if the officer hadn't done what they were supposed to. So when it's working well, it's a great system.
For sure.
And the issue has been, though, is that back when we were all prosecutors, or at least when I was a prosecutor, it used to be that they had a criteria over what prosecutors were allowed to work intake. And even if you were allowed to work intake, there were rules about what cases you could handle. I don't, y'all were a little bit younger than me, or a lot of bit younger than me.
Same thing though when we started working.
Yeah.
But it used to be the rule when I was there was that you weren't supposed to either take or reject a charge that you were not allowed to try based on your position
Right, handle in
in
court.
the office. If you were a misdemeanor 3, you had no business analyzing whether or not a murder case was
Exactly.
strong. And under the Ogg administration, it seems that kind of all caution's been thrown to the wind over who gets to handle what. And so if y'all could describe that a little bit.
I would say that I think a murder still has to go through a chief on the desk or somebody that might be permanent intake. I'm not sure how many permanent intake prosecutors are authorized to take those, but you have to also remember the inexperience that's on the desk as well. So there's that.
And what does that mean? I mean, when you talk about the inexperience, what are you talking about exactly?
Several things. I think one of them, overall, the experience level at the office. I mean, we know there's still senior prosecutors there, but people are being promoted to chief who've been at the office for less than
2 years?
2 years.
Yeah.
3?
So,
3?
How long did it take y'all to make chief? It took me 7 years. I guess I was in the slow class, but
at least 7,
yeah.
6 or 7.
Yeah, I think I was 5. But I was made chief under Ogg, so things were moving faster. Yeah,
You were
because
accelerated class.
yes.
So there's that aspect of it. But then you also have people being hired directly into intake, and she slowly was ramping that up. When she first started to change intake, it was a gradual build. She didn't just say, none of y'all can work intake anymore, it's all permanent hires. She slowly was giving up the overtime shifts and the day jobs and hiring people, and now it is mostly fully staffed by people who are working there
I
permanently.
mean, the wild thing about Kim Ogg and intake is that she really, and she still holds on to this argument to this day, is that these prosecutors are just using it for overtime. And it's like, okay, yeah, the overtime was great, but intake still sucked. Like no one was just like, yes, 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 work in intake. It sucked. You had to write warrants. You had to explain yourself if you took a bad charge. You had to explain yourself if you declined a good charge. I mean, all intake brought you was trouble and extra money. Like nothing good came from intake except that paycheck. So she's
But they don't have that
insane.
anymore, because when you don't rotate and you're there permanently, one, we're hiring people that haven't been, you used to have to work misdemeanor 6 months before you could even work misdemeanor intake.
And then
you had to observe six shifts
times,
before you could even work.
Yeah.
Now, if you are hired directly into intake, you're not going to the trial courts, you're not doing any of that. So you're taking charges without any concept of how does this play out in court?
Right.
What are the things I should have asked the officer to tag or to get or ask before?
Yeah.
None of that, you don't have that concept. Additionally, intake is a grind, and if you're going to work it every single day, years on end, you're going to become a little numb.
Yeah,
Yes.
no, I remember, because like when I was promoted to chief, my first gig as a chief, which was the traditional
Right.
pattern
You got
back then, was
promoted
you
to go,
had
yeah.
to go to the desk and you had to work it until like a chief actually
another
left
promotion.
the court. And I was there for 9 months, and
Ew.
I hated life. Like it was just like, it was an 8 to 5 job, but I was going in, and I mean I hated being a prosecutor, because the intake job is not like being a line prosecutor where you get to go to court and you get to try cases and communicate with people. It's just sitting at a desk taking phone call after phone call and writing warrant after warrant. It's a miserable thing. So it's funny.
If you work with Justin Kiter and you don't realize he puts signs outside all the offices that says take your warrants to this office.
There is a lot of room for practical jokes in there, but you know, but it's hilarious. I didn't know that Kim actually said that it was like some sort of cush money making machine.
Oh, yeah.
I mean, it was miserable. I mean,
Oh, yeah.
you know,
But like that was just her thing, right?
She thought it was a bad look, and
Yeah.
you know that
Shut
you should be
up,
focusing
Kim.
on your work in court and not just trying to make your overtime money.
She's awful.
So we've pumped in a lot of inexperienced people.
There's a lot of inexperienced people. They're not rotating. There's no follow through to how, you know, if I get to court, do I want to prosecute this case? They are, you said it best the other day, they're just isolated. It's a vacuum. So
Well, and it's also
they're saying yes, and they have no concept. They've lost sight of we're actually arresting somebody. And is this
She
going to
has-
hold up in the courtroom?
Right. She has created an intake division of ease and convenience.
Yeah.
Like that's how I love to describe it, because I have heard from people who have worked the desk recently. And they say it's just easier to accept the charge.
Sure.
It's just easier. And I never saw it that way when we were working intake. It is not easier to accept the charge when you're going to get trouble from someone
And
else
when you
later.
don't have to see the consequences of your actions.
Right.
Just think of the mere act of, have you ever watched a cop get cross-examined? And if you've never been a line prosecutor in trial, you're just a person who answers the phone when the cop tells you just how everything's going to go, and you have no concept of, well, this is what a defense attorney's going to ask you about, and you're going to be sputtering because you don't know how to back it up. And so getting back to this article, what we've been seeing for a long time,
It's been a running joke.
under the DA's office, it really is a running joke amongst the defense bar. Like, what's the stupidest charge that you've ever had coming out of intake? And some of them are just legendary. And today, the Chronicle actually did an article on it, because why don't y'all tell us what happens next in court when a dumb charge meets a smart judge?
Hopefully there's a swift finding of no probable cause, as I think you witnessed today.
I did. And what does that mean for the folks who don't practice criminal law?
If no probable cause is found, you are discharged from the case, meaning if you're on bond, you are released from bond. You are not tied to the case with any obligation, to return. If you're in custody, you're released. But what a lot of people didn't realize, and in fact, I think even some of the reporters who worked on the story didn't realize until they were doing it, every time somebody has a finding of no PC, unless it's the rare case where it's a warrant where they do, present themselves in court to the judge with a bondsman, that person has already been arrested.
Yeah.
They have been taken to the Joint Processing Center. They have been booked in. Unless they hurry up and get out on some sort of bond quickly, they're waiting to see a magistrate. You've already had a lot of serious things happen for a case that there was no probable cause on. Nobody's planning to get arrested.
Yeah.
So what happens to your kids? What happens to your job that you don't show up to that day? What happens to your car that gets towed and you don't have the 500 bucks?
2 days ago, while I was driving, they said, "Mom, what happens if you get arrested?"
Right.
Like, where's this coming from?
Why were they asking?
Yeah, where's this coming from?
Cheryl?
But terrible things would happen. But I mean, there's a lot of things that go, or there's a lot of reasons right now why I think the judges are finding no probable cause. One is because intake is accepting trash charges. They're trash. Like, you don't charge someone with an ag assault because they threw a pineapple at someone.
Well, and even the ones where probable cause is found, there are so many overcharges, like things that are filed as felony that should be misdemeanor.
Right. Like if you're a police officer
another problem
and
with
someone
intake
shoves
and
you
experience.
while they're getting on the bus, like that's not assault of a peace officer. But if you lie and say you got shoved down to the ground, it's different. But those charges are overcharged. Another reason, though, is that the dockets are getting insanely out of control because the prosecutors themselves, even the people that have been promoted to chief, although there are some great ones, there are some chiefs that are great, but a lot of those chiefs, they feel like they don't have discretion. They're worried about getting in trouble. And so when you don't have discretion, when you're not doing or making the hard decisions, you're letting your docket size grow. And then these judges are getting frustrated that you have serious charges, violent crimes, things that need to be tended to, but you don't get to it because you're dealing with all this other crap. So they're going to find no probable cause on these trash cases that come in. And then the DA's office feels the need to fight them on it. Right. And it's so insane.
It is, because there's so much inexperience right now in the DA's office that there are too many prosecutors that don't realize that when a judge is finding no probable cause on a case, they're actually doing the prosecutor a huge favor as well.
Unless something drastic changes, what do you think is going to happen when you try that case in front of that judge?
Right.
So I recently heard that, and this brings me to a different point that's completely irrelevant than what we're talking to, but I recently talked to some people out in Fort Bend. Donna Logan had recently done a training out in Fort Bend, and one of the things that she said was, when you have a bad case in your hands, you should do everything you can to make it the last time that case touches your hands, right? It shouldn't go to anyone else. It shouldn't waste any more of your time, because usually those bad cases are never going to get better, right? They're just going to get worse. That's what a no PC is for, right? The judge is helping you get rid of that bad case. Let them help you. But also, Harris County needs some training.
Harris County does, because
if Donna Logan help him out.
Well,
Where are you?
And Donna Logan, for those of you that don't know, she was a senior prosecutor in Harris County. That, I don't know, did she leave under the Ogg administration or before? I can't remember.
I think she left before.
Yeah, I think it was before. Yeah.
Yeah. Now she's. And she's one of my favorites. I think the world of Donna, and she's got integrity, and she's not the person that's going to pass the buck. But I think Donna's also the type of prosecutor that says, if I'm going to be yelled at by a supervisor, okay, I'll take it, and she's not afraid of that.
Right.
And I don't think you have that culture at all in Harris County anymore. And they're almost like, they almost treat a finding of no PC from the court like, I'm going to be in so much trouble when I get back to the office.
But they might be.
Because you never know.
They really might be.
The changing policies and gut reactions to things that are perceived as negative press, it's an ever-changing, you don't know what you're going to get in trouble for, and it's easier to not make a decision. And you can't get in trouble if you don't do anything.
Right.
The other thing, and I've always said this about.
I feel like I got in trouble for not doing anything.
Well, that's true. we did.
Refusing to do
okay.
something
We,
is a little more active than being passive.
I have always said about intake before the AUG administration. Our system is the Harris County system is great. Like it gets people in front of magistrates more quickly. Judicial review, a prosecutor is supposed to be filtering, but at the end of the day, for the most part, I'm not talking about the big investigations that go through specialty divisions
Right.
and things like that. You're not on the phone with an officer for very long, okay?
No.
It's like a couple
Yeah.
minutes. And so what you have to keep in mind as a prosecutor is even though it made it through intake and it made it through probable cause, you are going to learn more about a case when you get all of the discovery, when you, just like other places that review all that before formally charging. Once you read the offense report, once you see what the witnesses say, once you learn of new witnesses or see, you have to accept, and I just always used to say about 30%, I just pulled that figure out of the air. There are still going to be a chunk of cases
There may
that
be a
made
job
it,
for you at Avocor.
that made it through intake that ultimately probably need to be dismissed.
Right.
Because you learn more and you have to be open to that. And if you are in an environment where, one, crummy charges are coming through that should be caught in the filter, and two, you have a culture where you cannot make decisions without the fear of getting in trouble or upsetting somebody or getting yelled at for dismissals or being questioned about your dismissals, the crud is hanging around even longer.
Right. Because yeah, it's like literally you've polished a turd, and you're treating it like a treasured family heirloom, no matter how bad it is. And what younger prosecutors don't seem to realize is that the older it gets, the worse it stinks. You know, when you're sitting there and you're on trial date and saying, y'all didn't pay attention back in the early days, and now we're set for trial, and you're going to have to explain to maybe a victim's family why this case is, for the past 3 years, you've been telling them you're going to go get justice for them in court when you never could have. And you have to do that. I mean, it's sad that it's almost like we deal with more trial day dismissals than we do with prosecutors who are cool with the no PC finding. And
Right.
Because
That's so sad.
and
Yeah.
it's like, wow, and that's just there's nobody that can say with a straight face that that's justice.
Right. It's an interesting point too, because trial day dismissals, right? And they're so upset with a no probable cause. But that's why working intake is also so important, is because working intake, as stupid as it sounds, you learn the elements of crimes. I mean, they should already know elements of crimes, but listening to some of these new prosecutors read PC is like making me want to die.
Well, and you learn how little you really have to go on when charges are being accepted, so don't be so
Right. Or you
hold on to every single case like it's the best case in the world just because it got filed through intake.
Well,
Right.
yeah, and it used to be that you would have a hierarchy within whoever was working there. You would have a chief on duty who was senior, and you would have somebody that was young. And so, like, if you were a young baby prosecutor, this was your first time to interact with senior personnel, and you could learn a lot, and you could bounce things off of them. I can remember working intake one time, and somebody called in because a cop called in because like someone had run out on their lap dance at Treasures without paying for it, and
Theft of service.
the cop called in wanting me to take theft of service, and I was like, and I remember Vic Weisner, who was a senior chief at the time, yelling from the other room, "Don't you dare take that!" and you know, you had that benefit of someone like you didn't take. I mean, technically, that may have met the letter of the law, but who on earth would ever want to take a case like that to trial?
Well, and there was rotating, like different people worked different shifts. You got to interact with more of the office.
Yeah.
You got to learn from different people instead of, you know, the same group of people you typically see on a daily basis. And
Yeah, that was invaluable.
That was
great.
like, oh, I wish I, would end up in that person's court, or things that you
Right.
you got to pick up on more things than you have exposure to when you're just in your lane.
Well, and so getting back to the article, the article, we're sitting here venting, but this article pointed out what we've always known. And
I have to say, this article, one of my biggest complaints with a lot of news stories lately is that they try overly hard to appear fair and balanced. And I'm not saying the article wasn't fair,
yeah.
No, definitely.
but
tried
they
to do
didn't,
soft
they didn't
sell.
overreach
No,
Right.
not
to
at all.
try and make it balanced when there wasn't evidence there to balance it.
Right.
And I
Come for
I
her.
appreciated that.
Yeah, and the key thing was in the headline, which was thousands of people who shouldn't have been jailed. And, you know, and that's the thing that you hope for, certainly as a defense attorney, is because we don't deal with a lot of empathy from the general public. They're like, well,
Right.
they didn't want to go to jail, they shouldn't have committed a crime. And when you start throwing out the term that there are thousands of people that went to jail on unsustainable cases that shouldn't have been filed, you've got to hope that that wakes up, like your potential juror down the line, that just because someone has been charged with something doesn't mean that they did it, or, you know, by our standards.
One of the case that they featured, though, about the mother who was arrested
It's
at the
horrible.
airport.
Tell that story.
Sure. So, there were several. They couldn't fit everything, obviously, in the article. This woman was in an abusive relationship, an abusive marriage. There had been a divorce filed where she was attempting to leave. The husband's actions were so egregious that she finally withdrew the divorce because that was safer for her.
Under threat.
When she withdrew the divorce, any temporary orders regarding, you know, who could have the possession of the kid at what time or what place or under what parameters were no longer in place. As of July 2023, no orders had been in place because the divorce was dismissed. This arrest happened in September 2023. And airport personnel were somehow, there must have been some sort of entry based on the original temporary orders, like they put in NCIC, TCIC, or something like that. They stopped her, saw her with the kids. She is flying through Houston to go elsewhere, and detained her. They called the father, who sent over screenshots or an email with the old orders. If the divorce was from July, the orders were obviously before that.
Sure.
And took his word on it. She was trying to tell them, look, here's my emails from they didn't pay her any mind. She was actually nursing. Oh yes, she was nursing. They held the child with CPS at the airport until the father could fly in and take him, and he took off with the kid. She didn't see the kid for 3 weeks after that because he took off with the child. The officer emailed what the father had given him to the intake prosecutor. Now, to the officer's credit, a lot of field officers don't have the ability to get on the computer and verify court orders and things like that, but that's what intake is supposed to verify.
Right. I was like, you absolutely have to.
Right. And what I didn't know until very recently is that she was able to call her attorneys while she was at the airport for hours before they booked her. And the attorneys started calling from Colorado, are calling intake. They emailed the prosecutor who accepted the charge. He had been gone off shift for 30 minutes, but apparently never even opened the email until yesterday when asked if he received it. So from September until yesterday when asked.
That's a testament to the well-oiled machine.
Emailed the chief who was on duty at midnight that never responded. Also called intake and was hung up on by the chief. The following day, they had already retained local counsel who had forwarded on the orders to the public defender's office, who got everybody on the same page and emailed to the magistrate, hey, here's these orders, they're not in place. How can you look at temporary orders from at least before July in September and feel comfortable arresting somebody on that when you can't confirm them? And then when somebody's emailing them, if you were a chief working intake, even if you didn't accept the charge and you didn't know what it was, if you got an email that says you are placing a mother and child in danger, would you not go to the log manager and say, hey, has something come through on the system with this name? Can I at least look and see what you're talking about?
Generally, that charge isn't something that you deal with at intake anyway.
Right.
That very recently changed. Those charges used to go through
Kim is
family
killing
violence.
She's just doing so great, you guys.
Because of the complicated intersections.
So many good
of law.
policies, just the best policies.
And when the prosecutor was confronted with the paperwork that they had no choice but to look at because the magistrate is pointing it out, they doubled down and refiled it as a misdemeanor because they said the misdemeanor doesn't require a court order, regardless of the intent that they never had. Yeah. This mother had to pump herself with her hand in the jail, had no equipment, was there for hours, lost her kid for 3 weeks. Can you imagine?
No.
And she had done literally nothing wrong.
She had done nothing wrong but try to flee with her child from an abusive relationship.
But she was back. She wasn't even in the process of doing that at the time of the arrest, was my understanding.
Well, no, she had left, and she had flown out of Denver and was in Houston.
Well,
And interestingly, one that wasn't featured that I saw recently filed, and thankfully the magistrate did not sign off on the 2B warrant. Somebody at intake on scene, an officer calls and says, I have a dad here. He just showed me possession orders in this family law case. The mom has not brought the child for his custody terms. I called her and she said, I'm at the station filing a report, and hung up. So will you accept charges for interference with child custody? Yes, we will. And they did a 2B. What was she at the station filing a report for? The domestic violence that was on video. She didn't want to take her child to custody drop off because she had just been assaulted and was going to the report to report it. He was already had a PTI successfully completed for family. They didn't even run him. He had all kinds of domestic violence on her.
Dang.
They filed a 2B, and thank God, whatever magistrate was reviewing it did not sign it. It wasn't dismissed till months later, and he then was charged with the felony family violence that she was reporting.
Well, and when Kim Og took over in 2016, she fired all these people, and I can say this as someone who's been fired by a DA, not Kim Og. A lot of them said they're making the county less safe. And you're like, okay, calm down, justice goes on whether or not what the prosecutor is. But in this case, she really has made the county unsafe. And you have so much more of a likely chance of being arrested when you've done nothing wrong.
Right.
Due to the inexperience.
But how wild is it that one DA has made it unsafe on both ends of the spectrum?
But she
like
keeps
you're getting
talking about
arrested and you haven't done
safety.
anything, and you're going free if you've actually murdered someone. She's really done both.
all the people, and she's very good at talking to crime victims and crime victim advocates and getting people, all the things that she's supposedly doing.
Yeah.
I'll give her that. She's good at
talking to people who don't
advocating
know
this.
what she's talking
But
about.
what they don't understand is, just as much as you just care about the people being arrested. No, people making the wrong decisions at intake can be a danger to all of us as well.
Sure, civil
when
rights
you don't
violations.
take the right charge. Well, no, like if you don't ask the right questions and you think, that's not a charge, I'm not taking it, you could be leaving somebody in a dangerous situation. I mean, it goes both ways.
Well, and one of the things that's kind of an addendum, I mean, the article that was out today was long.
Good. I did
great.
not
It was
know
great.
that all the different avenues
it-
they had gone down to investigate.
Yeah, it was great.
It was great and it was long, but one of the things that they just didn't have the space for, but that we all know, is that when judges are finding no probable cause, is that if the district attorney's office disagrees with that, they have a remedy, and that's to take the case into grand jury to get an indictment which would override the judge's finding of no PC. And they ought to do a follow-up story on the astounding amount of times that they do that. Even though
There was a chart in there.
Yeah, I
right?
saw it.
It was
but
like double from
right.
2022 to 2020 or something
Right.
like that. Oops, sorry.
Oh, you're good. But but no, but I mean, I think that's an individual story just in and of itself, is how many times they're taking things into grand jury to supersede, what a judge is saying.
It's overall, I mean, they're definitely doing that, but it's not like they're not taking every single one. And so if you're going to publicly complain about the judges and say that the no PCs are all because the judges are just finding no PC on valid cases because of their philosophies, well, then you think you'd be taking more of them in.
So-
I don't want to give them any ideas, but
So just so y'all know, we've got 3 minutes left.
Okay.
This tends to go by pretty quickly, but talking about how these cases ultimately end up, you see them in trial. HCCLA, we have a listserv and we get notifications. There are 3 big cases. I know that Corey Roth and Cindy Henley, one, was there a sexual assault case, I think, that they got a
I
not
think it was
guilty
some
on?
sort of child abuse, sexual abuse type case. I don't know for sure.
And and not guilties do matter for one of 2 reasons. Either one, you had the evidence and you couldn't prove it to a jury, or two, you shouldn't have ever brought it. And I don't know enough about the facts of these cases, but when you start having this significant amount of not guilties, it kind of does harken back to maybe you should have listened if the judge found no PC.
Or is Kim Ogg really keeping us safe like she says she is? Right. Because when you try a murder as a prosecutor, I'm not saying there aren't I mean, you should be picking the cases that are righteous.
Yeah.
That as a member of our community, we would hope that you would be holding people accountable for legitimate violent crime.
I mean, the culture is just different. Like, you used to be terrified to get a not guilty. And like you cannot convince me that the culture in that office right now is terrified to get a not guilty.
They just blame the judges.
Exactly.
It's the judges.
It's like, well, how about you evaluate it? Look
the judge
at it.
made bad
Listen to
rulings.
me.
So in addition to Cynthia and Corey, we also had Cheryl Brown got a not guilty in a felony case, and Danny Easterling on an arson case. So it was a pretty strong showing this week by the defense bar, and those are all great attorneys. And
also a strong showing from Kelly Benavides, who is babysitting 3 of our children.
Thank you, KB.
She wanted a shout out to KB.
And we're working on some segment shows that Kelly Benavides is going to be doing on that.
Hopefully.
I think that would make this show wildly entertaining. It's been saying that we were at 2 minutes. Now we're at 1 minute. I was like, that's a long. We've been on that same minute
60
there for
seconds.
a while. Yeah. So, but yeah, I mean, the state of the district attorney's office in criminal justice in general right now, I think, is in a tremendous amount of disarray, and we are a little bit short on time. So let's just kind of go to final thoughts. Lauren, what do you got?
4 more years of Kim Ogg, and I don't know if the county can recover.
Well,
we may already be at that
Agreed.
point.
Fool me once.
Yeah.
Shame on you.
Okay. What?
No, my final thoughts are there's still some good people in that office.
Absolutely.
And we have to have good people in that office. And I am so thankful that there are some good people still in that office, but man, it needs help.
It does need a lot of help, and it needs, I think it needs just kind of a culture shift on what it all means. So we're down to 30 seconds. Thank you for tuning in. Thank you, Lauren Byrne, Cheryl Chapell, for joining us on a wildly entertaining episode of Reasonable Doubt. And we look forward to seeing you guys in the weeks to come. We're going to have some candidates up on some of the contested races. I look forward to that. So anyway, thank you for tuning in, and we will see you next time.